Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. So the topic for today's video is the journey of a civil trial. From the presentation of a plaint to the final judgment given by the court, there are various stages involved in a civil trial. I will be talking about those stages in this video. So let's get started. Now the first stage is the plaint. Under Order 7, the entire legal machinery under the Civil Procedure Code is set in motion by the presentation of a plaint, and hence it is the starting point in all the pleadings of the case. The next comes the service of summons. It is an instrument by which the court commences a civil action or proceedings, and it means to acquire jurisdiction over the party. It is a process directed to a proper officer requiring him to notify the person named in the plaint that an action has been commenced against him and that he is required to appear. Now, the next stage is the ex parte decree. An ex parte decree is basically a decree against the defendant without hearing him or in his absence. Such a decree can be passed under three circumstances. First, where any party or from whom the written statement is required fails to present the same within the time permitted by the court, as the case may be, the court shall pronounce a judgment or against him or draw any such judgment or decree as it deems fit under Order 8, Rule 10 of the CPC. Now, the second circumstance may be where a defendant has not filed a pleading. It shall be lawful for the court to pronounce a judgment on the basis of facts contained in the plaint, except where against a person with disability under Order 8, Rule 5. Now, the third circumstance may be when the plaintiff appears and the defendant does not appear when the suit is called up for hearing, whereas the summons have been properly served by the court, may make an order that the suit will be heard ex parte under Order 9, Rule 6. Now, next comes interlocutory proceedings. The period involved between the initiation and disposal of a litigation is substantially long. The intervention of the court may sometimes be required to maintain the position as it prevailed on the date of the starting of the litigation. In legal parlance, it is known as status quo. And in that context, interlocutory orders are the provisional, interim, or temporary as compared to the final order. It does not finally determine the cause of action, but it only decides some intervening matter pertaining to the issue. Now let us now here understand what is a written statement. Now the defendant is required to file a written statement in his defense at or before such hearing or before such time as that has been allowed by the court. If the defendant disputes the maintainability of the suit or takes a plea that the transaction is void, it must be specifically stated. The denial must be specific. The denial should not be evasive, but it must be on the point of substance, and every allegation that has been made in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleading, shall be deemed to have been admitted under Order 8, Rule 5 of the CPC. Now, the next stage is the production of documents. After filing written statement by the defendant, the next stage of the suit is the documents. On this stage, both the parties have to file documents in the court which are in their possession or power. If the parties rely on some documents which they are not having in possession or they do not have the power to get, in that case they may have to apply to the court for the issue of summon to authority or the persons who have the possession of the documents. Now, the next stage is the examination of parties, which has been provisioned under Order 10 of the Civil Procedure Code. Examination of the parties is an important stage after appearance. At the first hearing of the suit, the court shall ascertain from the party or his pleader whether he admits or denies such allegations of the facts that have been made in the plaint or the written statement. Such admission or denials are recorded. The examination may be an oral examination. Now, when a party or his pleader who appears or refuses or is unable to answer any material question, the court may direct that the concerned party should be present in the court. If the party does not remain present in the court, it can pass such order that it may deem fit under Order 10 of the CPC. Now, the next stage is discovery and inspection. Under Order 11 of the Civil Procedure Code, the purpose of discovery and inspection of the document and facts is to enable the parties to ascertain that what facts are to be proved. With the leave of the court, the plaintiff or the defendant may deliver interrogatories in writing for the examination of the opposite parties, which are required to be answered and which are related to the matter. Now, I will be describing the further stages in the next video. Please watch the next video. Thank you so much for watching this one, and please subscribe to the channel for further updates.